Hello, everyone. I am Gwen Seal, an entertainment lawyer at Mike Tolleson and Associates in Austin, and welcome to Copyright Essentials for Musicians. This project was generously funded by the Texas Commission on the Arts, the National Endowment for the Arts, and the Mid-America Arts Alliance, and supported in part by the City of Austin Cultural Arts Division. We thank all of these organizations for their generosity. We are so fortunate to have with us today panelists from the United States Copyright Office. Because who better to explain copyright law and the importance of registering your works with the Copyright Office than folks from the Copyright Office? The answer is, well, no one. So let's first introduce our first panelist, John Riley. John is an assistant general counsel at the Copyright Office, where he has contributed to the United States government's briefs in the Petrella and Area Supreme Court cases, the Copyright Small Claims, Copyright in the Music Marketplace, Section 1201 of Title 17, and among other regulatory work, has authored rules implementing the Music Modernization Act, the CASE Act of 2020, and the Graham registration option. Next, we have Holland Gormley. Holland is a public affairs specialist with the U.S. Copyright Office, where she specializes in outreach to creative communities. Prior to joining the Copyright Office, Holland worked in communications and project management roles at private, nonprofit, and governmental arts organizations, including the State Department's Hip Hop Diplomacy Program and the National Endowment for the Arts Music Division. So to provide a brief overview of what we will be covering today, we're first going to start with the basics of copyright. So if you don't know what copyright law is and what it protects, then you're going to learn that today. And if you happen to understand copyright, well, then that part will be a review for you. From there, we will then dive straight into copyright in the context of music, information on registering works with the Copyright Office, and then delve into specific issues that I see confusion in the music community. For example, collaborating with other songwriters and other artists, joint authorship and joint ownership of works, and then also utilization of pre-existing works, such as samples, remixes, and beats. And then we're also going to sprinkle in some information on the Music Modernization Act and the newly established Mechanical Licensing Collective. So without further ado, we are going to begin this presentation by starting off with John. John, what is copyright?
Thanks, Gwen. And, I should start off by saying, thank you very much for inviting us to come speak to everyone and for the sponsors of this program. We really do appreciate it. And Holland and I love going out and talking to people in the world because even though it's virtual right now, we're getting out of our offices a bit in DC and, being able to talk to folks is one of the greater parts of our job. I will say, to answer your question, what is copyright? The nerdy answer is it's really the laws that protect people's creative efforts. When you write a book, when you make a movie or create music, you're producing a copyrighted work, and the law of copyright protects you. The really nerdy answer is that copyright protects original works of authorship fixed in a tangible medium of expression. And in this context, original really consists of two components. It has to be independently created, so not copied, and it has to be sufficiently creative.
Yeah, John, I want to add on to that nerdy answer by saying that in addition to books and music and movies, copyright also protects things like choreography, architecture, and even computer games. So whether you're a fan of, say, video games or dance or novels or any other creative endeavor, copyright helps you make a career in that creative pursuit. And it also protects you against other people infringing on your work. I also want to mention what copyright doesn't protect. It doesn't protect unoriginal works such as words and short phrases. It doesn't protect familiar symbols or designs like hearts or smiley faces. It doesn't protect variations on typography or systems, ideas, procedures, processes, stuff like that. So when you think about copyright, think about creativity, not inventions. So before we get too much farther along, I do want to share something super important, especially to me from a public affairs perspective. Copyright law is super complex. So There's no dumb questions here today except for the ones that you don't ask. If you have questions, please feel free to pop those over into the comment section. We can't offer specific legal guidance or answer questions about copyright registrations or disputes, but I can promise that we'll give you an overview on what copyright is and how you can apply it to musical fields, if that sounds good to everyone.
And I'll just add, if you can't tell, although I work in our general counsel's office, Holland translates all of my legalese into actual, easy to understand language. So
yeah, I speak lawyer.
Right, exactly.
But I don't play one on TV.
There you go.
So, John, first question for you. How do you determine who owns a copyright once it's created?
So copyright vests in the author of a work. So like the short version of that is the person who creates the work is the copyright owner. But that has a lot of caveats, as you see on the screen. So you can be an author as a joint author. And so multiple people can create a work at the same time. We're going to talk about that a little bit more in a minute, but for the lawyers on the call, think about that as creating a tenancy in common, right? So if you're a joint author, you can use the whole of the work, even though there are other people that contributed parts to it. Authors can also be anonymous or use a pseudonym as a name. So like think Samuel Clemens used Mark Twain, and or what is it? This is what you came for. Taylor Swift used Niels Schloberg. I can't even say that, but think of pseudonyms like that. And interestingly, in the copyright world, a person, a corporation, or other entity who hires somebody else to create a work is both considered an author and the copyright owner at first blush. So that type of work is called a work made for hire. But the law says that a work made for hire can only come up in two ways. One, if you're an employee working in the course of your employment. So if they're your regular duties, then you might be an employee who is creating a work for hire. Or if the work was specially ordered or commissioned for use as a contribution to a collective work, as part of a motion picture or audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test or test answer, or as an atlas. And so that's a very specific set of works that can be created by contract and not by employee. And the parties must expressly agree in writing that the work is a work made for hire. So some examples of work made for hire would be like a graphics team that produces advertising in-house, or someone who's commissioned to create a film score and their signed contract says that the score is a work made for hire. And so while the author is the original copyright owner, the rights can be transferred to a successor, an assignee, or a licensee.
Great. So Holland, how long does copyright protection last?
So this is probably my favorite part about copyright. Copyright is an automatic right, and that means that you don't need to do anything to get this right. Copyright exists from the moment your work is fixed in a tangible form of expression, like when you record a song or when you write a musical work down using like notation. I know I just mentioned that copyright is a really complex area of the law, but elementary school kids are great at this concept. They know that when they create something, as soon as they create it, it is theirs. That belongs to them, and they'll get really annoyed if you copy it. So, I know I said it was complicated, but maybe it's not that complicated after all.
So let's talk about term of copyright. And either John or Holland, feel free to jump in here.
I can give a short answer if you'd like, and then John can give the long answer. My favorite way to answer this is it depends on how long copyright lasts. But John, I think that you probably want to chime in there with some more specifics.
Yeah, Holland is a lawyer at heart, really, I feel, because that is a very lawyerly answer. But it does.
Yeah, definitely.
it does depend on a few things. Under the current law, any work created now for a single author of a work, it's going to be life plus 70. So the term will extend for 70 years after the author's death. And for joint works, that's actually a measuring period from the surviving author. Now, so if one author dies, in 2025 and one author dies in 2030 would be the measuring point for a jointly authored work. And I don't know if that's why DJ Khaled has his son be a co-author on some of his works, but if he did, that would be a good idea if you wanted to extend the protection period for your work. For those works that I was mentioning before, the anonymous or works using a pseudonym, it would be 95 years from publication or 120 years from creation, whichever is shorter. And that makes some sense because we're not going to know when an anonymous author is going to die. And of course, a corporate author, could live forever. So we need to have some definite time periods where the copyright term will end. And then we're not going to get into it now. There's a lot of resources online that you could find, but anything created before 1978 will have a different timeline because the rules were different. And then there was a number of extensions. Some of them required some formalities, some didn't. So I would just consult a lawyer or some useful websites for that answer because it can get very complicated.
Yes, very complicated. So John, now what exclusive rights come with copyright?
All right. So when we say exclusive rights, we mean you can exclude others from exercising these rights. And so the following rights are the ones that the copyright statute grants. So as you might understand, copying or reproducing a work is one of the core rights of copyright. Another one is to distribute copies of a work. So for example, if you were a record company and you reproduced a record, that reproduction would cover the reproduction right. But if you're a store selling the work, that might cover the distribution right? So different uses are covered by the law. It's not just the reproduction right. And so those two are pretty self-explanatory. A little one that's a little bit more complicated to understand is to prepare a derivative work based on the original work. And so a derivative work is based on or derived from one or more pre-existing works. So it could cover remixes, using a sample in a new work, or using music in TV, advertising, and the like. And when you create a derivative work, the copyright that you get, the protection that you get is from the difference between the first work and the second work. So let's say I write a novel and then I want to edit the novel and create a second version, or maybe a textbook's a better example. So the first version of the textbook would get a copyright, and then the difference between the first and the second, which sometimes we refer to as the delta, it's just the difference, that would get protection under the derivative work rules. So those rules may, depending on who's the author and what else is going on, may have different terms. But in essence, when you get a derivative work copyright, you're only getting rights in the difference. And then the trickier ones, not because they're conceptually tricky, but the rules actually apply a little differently, are for public performance and display. So if you're going to publicly perform a work, know that there's actually a couple of big asterisks there because well, frankly, I have to introduce something we're going to talk about shortly, but one of the biggest concepts in music law is that there's a difference between a musical work and a sound recording, and they have different rights. So the performance rights for sound recordings are actually only limited to digital audio transmissions. And that's an interesting thing because it is not limited so much for the musical work right. And we'll talk about the differences between those two in a second. But similarly, publicly displaying a work, that also doesn't cover a sound recording, and that actually makes more sense because how are you going to publicly display like a waveform on a wall, right? That you just wouldn't understand like a squiggly line wave as a sound recording. So maybe that would make some sense. The public performance one makes a little less sense.
So John, I think you started to hint at the two distinct copyrights as it relates to music. So could you explain these in a little greater detail?
I can take this one. So thanks for the tee up, y'all. So, like John just mentioned, when you record a song, right, you may be creating two works, depending on what you're doing, that are protected by copyright. There's a musical work, which is the written version of a song or a composition. And then there's the sound recording, right, which is the the actual, what we think of as like the music that we're listening to. So these works are subject to different rules, as John alluded to, and they're typically owned and licensed separately. A musical work, like I mentioned, is a song's underlying composition along with accompanying lyrics. And they're usually created by a songwriter, lyricist, or a composer. In contrast, a sound recording is a series of musical, spoken, or other sounds that are recorded in a recording medium, such as a CD, or more commonplace these days, a digital file. And we call those phonorecords in the Copyright Office. Sound recordings are created by their performer and the producer of the recording. So my personal favorite example to illustrate this point is Dolly Parton, who owns the copyright to the musical work I Will Always Love You, an iconic classic. And Whitney Houston also owns the copyright to her sound recording of that song.
Yeah, and so, I mean, my New Year's, this is the example, the Whitney Houston, Dolly Parton example is what kind of all, people talking about this issue bring up. But I like switching it up because it's my New Year's resolution to find different examples of that concept. So for some different examples, Bob Dylan wrote All Along the Watchtower and Jimi Hendrix recorded it. So Bob Dylan's publisher owns the musical work, and Jimi Hendrix record label would own the sound recording. So the same would be true for Carole King's song Natural Woman and Aretha's recording of that song, or for Prince and Manic Monday, or for Prince and Nothing Compares to You, or for Prince and Jungle Love, or for Prince and I Feel You. Like, the point is Prince writes a lot of music, all right? So I think you get the gist of that. So, okay, this slide here, it's a little hard to see the middle row, but that talks and illustrates more about what we were just talking about. You'll see that sound recordings have less rights than musical works. So in case of publicly displaying a work, that makes sense. As we talked about before, and the oddity of the full public performance rights, sound recording copyright owners do not have that, but musical work owners do have a full public performance right. So what does that actually mean? So for sound recordings, I said before, it's limited to digital audio transmissions. So that means interactive streaming, satellite radio, webcasting, and the like. And if you're looking for real world examples, I would say, Spotify, SiriusXM, and Pandora. But for over-the-air, regular AM, FM radio, sound recording owners don't have those rights, so they don't get paid for those uses, which is an oddity.
So let's shift gears here and talk about collaborations and joint ownership and joint authorship of musical works. So can you explain what it means to be a joint owner of a musical work or a sound recording?
Sure. I will say first, I'll talk a bit about joint authors, who are a type of joint owners. So remember, if two more people create a work and they intended that their contributions are merged into inseparable or interdependent parts of a unitary whole, and like that is legalese, so bear with me, both creators are authors of the joint work, or we'll call them joint authors for short. So think about, as I said, tenancy in common for the lawyers out there. They could use the work because, after all, they own it, right? But if they license the work, they would have to share their royalties with other joint owners of the work. And so there may be trickiness about whether joint work is created in the context of music. And I can't, as this is getting back to the point where I can't give legal advice, but think about like the different patterns that might arise, right? Like, so if you have a composer who has music but no lyrics, you have a lyricist, maybe they were writing poetry and they decided later to set it to music. In some circumstances, it makes some sense that these two creators could come together and combine their works and have it be considered a joint author situation, but there may be circumstances where that makes less sense. So it's really important to understand the circumstances of a work coming together, the creator's intent, and how inseparable their contributions are when you're considering whether a work ends up being a jointly created work. And as I kind of mentioned quickly, joint authors are one type of joint owner. You could also have joint owners when the copyright is split up. So for example, like if the three of us created work and I died and gave my rights to, I don't know, my best friend would step in my shoes and be a joint owner of the work with the both of you. But you had mentioned before, Gwen, I think you had said you saw some confusion in the music industry on this issue. I was wondering, what are you hearing?
Yeah, I mean, I think the first issue is just musicians understanding that there are two copyrights involved as it pertains to music. But, more than that, it seems to mainly come up when all of a sudden, you're dealing with a band and then disputes arise, right? All of a sudden, maybe selective memory comes into play. Maybe people just don't understand copyright. And situations arise where someone, thinks that, oh, well, just because I played the bass on this particular sound recording, that I also co-wrote the underlying musical work. It could be the case that that person did contribute to, writing the actual melody, maybe contributing to writing the lyrics. But it could also just be the case that there were people who actually wrote the underlying musical work, and then the bass player just happened to play bass on that particular sound recording. And so, the problem being that when there's no written agreements between collaborators, whether we're talking about between songwriters or between artists performing on an actual sound recording, problems arise when there are no written agreements, and particularly when all of a sudden money starts coming in, or when people start having disputes with one another. So ideally, if you're collaborating with other people, writing songs or performing on sound recordings, have written agreements in place. So, at the very least, if you are writing a song with some other co-writers, use split sheets. And these split sheets would basically be a document that identifies the ownership percentages of each particular co-writer, with each co-writer signing off on the split sheets. And if you're looking for split sheets, I know that the performing rights organizations, so like ASCAP and BMI, they have templates on their site. So if you just Google ASCAP songwriter split sheet, a split sheet will come up. And so, that's a good place to maybe start.
Yeah, I'll say that's kind of one of the benefits and challenges of copyright law is, in contrast to the olden days when some might have considered copyright to be an indivisible right, you can really chop up the rights that you have, whether it's the rights of public performance or ownership rights or anything that you can think of in the copyright law. But doing so can create challenges. So copyright is clearly, you can divisible, you can divide the rights up, but you have to really be thoughtful when you're doing that, because it could affect your legal rights or somebody else's. So all good points to get that at least on paper, so you don't have to guess at what parties' intentions were. But that is one of the interesting parts of copyright. It's ability to license and chop up rights in different ways.
And to piggyback off of that, I also just wanted to mention that if you happen to be a musician and someone hands you a contract that involves, anything copyright related, related to, works that you've collaborated on, make sure that you have a lawyer actually review it with you, so you can understand what that means, because the last thing you want to do is, sign your rights away without understanding what document you have signed. So just a practical piece of advice there. And speaking of dividing up rights, John, can you explain the difference between a copyright assignment and a license?
Sure. And you will see some people kind of use some terms that I'm going to be talking about interchangeably. So, keep that in mind if you're reading something outside here. But if I license the use of my work, I might want to divide the rights by kind of the rights in the Copyright Act. But I could also break up my rights by territory or time or whatever else I can think of. And when you give permission for someone to use your work, but you retain the other rights in the work, that's a license. An assignment is when you sign away all of your rights in a work to somebody else. Sometimes you'll see an assignment called an exclusive license, but the language could get a bit tricky, especially when it involves a joint work, as we were talking about before. So when a work is jointly owned, you can't really grant an exclusive license to the extent that it would exclude the other joint owners. Sometimes courts get caught up on this because a party must hold an exclusive right to have standing to bring a copyright infringement case.
And speaking of infringement, let's start shifting gears to actual registration of works with the Copyright Office. So Holland, can you explain the importance of registering works with the Copyright Office? And then we'll get into some of the typical applications that musicians might run into.
Yeah, totally, Gwen. This is like my favorite question at work. So I would be happy to. I know I mentioned earlier that copyright exists from the moment a work is fixed in a tangible medium. So we get a lot of questions about like, what's the difference between that automatic right and like copyright registration? Why should I do that? I would say that depending on what you want to do with your work, it's a good idea to go ahead and consider registering it with the U.S. Copyright Office for additional legal protections. I like to think of copyright registrations as requesting an official birth certificate for your work. It notes its parents, the creator, or you, and the date the work was created. Registering your work also gives you an official document called a certificate of registration and makes a public record of your ownership. And I should also mention that you do need to register if you want to bring a lawsuit for infringing your US work. And you have to do it within a certain amount of time to pursue statutory damages or attorney's fees in that lawsuit. So that's just another good reason. In short, my general advice would be to consider registering your work if you want to show you own it, if you plan on commercializing your work, or if you want to protect yourself against, copyright infringement. I should also mention that if you do register your work, please make sure you're doing it at the Copyright Office's website, copyright.gov. From time to time, there's imposter sites out there, which we at the Copyright Office can request be taken down because of intellectual property laws. So that's like a fun full circle moment. I should lastly mention that when you register your work, in most cases, you can do it online where you just upload your sample, through our portal and register for a fee, which varies based on the type of work. And I think that John will walk us through some of the different types of registration options.
Yeah, we thought it would be great to share some of the options that people typically use to register music, including multiple works at the same time. If you use the standard application and, as it's described, it is standard. It's not designed necessarily for music. There is one thing to know about it that might be helpful. You can actually record a musical work and a sound recording at the same time if you're the author of both. And if they're contained in the same container, like the same MP3, the same CD, the same track, called a phonorecord. But what you can't do is say, like, here is my sheet music, like the sheet music you see on screen, and that's the registration for my musical work. And here's the MP3 for my sound recording. So that wouldn't work for the standard application. But another option you can use is what we call the unit of publication option. So you can register multiple works with this that are physically packaged or bundled together. So this is usually used to register more than music. So board games are the very typical like unit of publication option because all the different creative works have been bundled together and they're sold, but you wouldn't want to have to, for example, individually register like the designs on a card in the board game and the board itself and the little character sculptures and stuff. So those would be in different classes, but the unit publication option would allow you to register it all at once. One drawback for this option is that all the works must be published and published on the same date, and the claimant must be the same. And so that sometimes presents challenges for musicians because, as we know, you might have a lead single that it's published before, and authors, especially authors of musical works, might be different on an album. Another option we have is the group registration of published works. This allows you to register up to 10 unpublished works in the same class. But again, it has the restriction that they all must be by the same author who's the same claimant. The more details on all of these registration options are available on our website. I'm just giving you the highlights right now because I'm going to end up telling you one option that we alluded to early in the program that I think a lot of people who work with musicians should really know about. Before we get to that one, we have one more though. It's a contribution to a collective work. So registrations for collective works. A collective work, I should say, protects the selection, coordination, and arrangement of independent works. But the registration for a contribution to a collective work would not only cover that selection, coordination, and arrangement, it could cover the component works if they're owned by the same party. And so there is the restriction that the component works must not have been previously published or registered. But this one actually is used by the music industry to a larger degree. And if you can guess, it's actually record companies who like this option because they select, coordinate, and arrange tracks, for example, on a CD. Sound recordings are frequently published all at once, except when you have a lead single. And the authors are typically all the same, at least of the sound recording. So music publishers, though, have a harder time with this option because the albums are frequently, have different musical work authors and owners, even if the sound recording authors and owners are the same. But we have a new option. So we addressed some of these problems with a new option called group registration of works on an album of music. And if you think that's a little wordy, it's because the acronym is GRAM. And yes, that's a reference to a gramophone. And because our group registration options all start with GR. And if nothing else, this slightly punny acronym is going to be my legacy at the Copyright Office because I wrote the rule and I got to give it its name. Don't judge me. This one, though, is very helpful because you could register up to 20 musical works or up to 20 sound recordings and any associated material contained in the album, like the graphics on the cover, the liner notes, things like that. It doesn't allow you to register videos, though, if you have one of those, CDs that contain videos on it, for example. If all the works are created by the same author or have at least one common author. And that's great because a lot of times you'll see, on an album, just think of how many times like one singer will contribute to, a musical work from different producers, for example. So you could have that one unifying author will qualify you as having the same author for this registration. And also the other requirement for this one, as is for a lot of our registration options, is the claimant for each work in the group must be the same. The works all don't have to be published on the same date, so it should be very helpful for especially musical work owners and sound recording owners who have their works published in the form of an album. And so we'd like to see people using this because it would be a lot cheaper to register works using this option than individually registering each work.
Great. And I do want to mention that this morning, when y'all got an email reminder about this particular webinar, there was a group of links to useful Copyright Office circulars, including this one on the GRAM application. And that link will also be in the comments on the YouTube video and the comments for this presentation. So just wanted to give y'all a heads up on that. Next, let's shift gears to using pre-existing works. We're going to begin by talking about covers, and then we'll move on to samples, remixes, interpolations, and beats. So Holland, I am going to ask you this question. What is a cover? Can you explain what that is and what an artist needs to do in order to record and distribute a cover of a musical work?
Yeah, totally. I'd be happy to. Before I get started, I did notice that somebody in the comments had a question about the standard app, and I wanted to just quickly pump our help desk at the Copyright Office. If you go to copyright.gov/help, there's like a whole team of really dedicated and creative copyright specialists that are happy to help you walk through those questions. So that's copyright.gov/help. Now I'll turn to covers, which is a question that we get a lot from the music community. So I'm happy to walk y'all through it. A cover or a cover song or a cover recording is made when a previously recorded musical work is re-recorded into a new sound recording. Some covers seek to imitate the earlier recording, while others may totally apply different interpretations, styles, sounds, what have you, right, to create a new arrangement. Only the musical work being re-recorded is implicated when you're creating a cover, though. So to make a cover, you can either secure a license from the musical work copyright owner or secure what is known as a statutory, and that's just another word for like compulsory, mechanical license. So again, you can secure a statutory mechanical license. A statutory mechanical license operates by law, which is just a fancy way of saying that a musical work copyright owner can't usually say no to that use if all of the legal requirements are satisfied. And that sort of statutory mechanical license can only be obtained for non-dramatic musical works. Complying with that license, though, I should note, can be complicated. There's several really specific rules that you'll need to follow carefully, including rules on who's eligible for the license, how much money or royalties must be paid to use the license, and other details. So I won't get into all of those now because, like I mentioned, it's complicated, but just a couple of popular covers that I want to flag for y'all as good examples are All Along the Watchtower by Jimi Hendrix. And of course, the original is by Bob Dylan, one of my faves. Or one of my all-time favorite examples, Hallelujah by Jeff Buckley, is a cover of the original by Leonard Cohen. I should note, too, that if you secure a statutory mechanical license, you're allowed to make a musical arrangement of the work, but the arrangement cannot change the basic melody or the fundamental character of that work.
Yeah, I see that there's a lot of comments, in the comment section. We're going to briefly touch on the MLC, but it's briefly because there's a lot of stuff that you can't get to in a single session for a webinar. But we did feel like we needed to mention that the statutory mechanical license, the fact that the government allows exceptions and limitations to copyright law is not odd, but I will say that it's very inconsistent what rights are really more or less regulated by the government and which are actually set rates for the government. The mechanical license is one of them. And, we'll talk about this a little bit more in a second, but we are skipping over some of the other statutory licenses and some of the details, for example, on the sound recording side, just because it's a shorter program. But I did want to flag with a reminder that recording a cover involves separate rights for performing a cover. So while Holland was mentioning the mechanical right, that statutory license for digital uses, those rights are kind of managed by either the copyright owner if they have a direct license, or for the statutory license, the MLC. But in contrast, the musical works performance rights are typically licensed by performing rights organizations like ASCAP, BMI, CSAC, and GMR. Now, if everything I just said was confusing to you, it is, and music is very confusing. To illustrate this slightly graphically, if you're going to perform a cover as a performance, you need to have a public performance license, and who licensed that? That's the PROs. That's ASCAP, BMI, CSAC, GMR. And then on the next slide, we'll see if you're going to record a cover, then you will need and this is the next slide, you're going to need a license for the reproduction and distribution rights for the musical work. If you're making CDs, records, or physical recordings, you actually get that from the copyright owner or through the statutory mechanical license, which is in Section 115 for the Copyright Act. And it's an interesting fact, but a fun one. The same statutory license applies for reproductions and distributions that are more than cover recordings. So even your original work those two rights still apply to you. But when a digital music provider sells digital downloads or engages in interactive streaming, for example, like on Spotify, Apple Music, or Amazon, they will get a mechanical license and can get it through the statutory license, which flows through the MLC. And a lot has changed with these rules in the past couple of years. And I think Holland, yep.
Yeah, I can hop in here. Yeah, so John talked a little bit about the MLC, and I do just want to give my 100-word spiel about the MLC and the MMA, or Music Modernization Act. I feel like probably most folks in this group are familiar with the MMA, but just to briefly recap, it replaces the previous song-by-song mechanical licensing structure for making and distributing musical works with a new blanket licensing system for digital music providers to pay royalties for interactive streaming. Songwriters and music publishers, y'all should now register with the MLC, who John just briefly mentioned. That's a nonprofit designated by the Copyright Office to receive and distribute royalties, and the old song-by-song mechanical licensing system remains in place for physical reproductions only now. So, and I should also mention that the MLC has a great help desk if you're having any questions on how to register with them. They should be able to assist.
And I also just wanted to mention that, later on this year, Tala will be doing a presentation on music publishing and publishing administration. And so we'll talk a lot more about the MLC at that point.
That's great.
That's great. I'm excited to tune into that one, Gwen.
Yeah.
I did want to pump to our some of our educational resources for performers and songwriters that are available on the Copyright Office's website. Here's one of them: how songwriters, composers, and performers get paid. I think maybe Gwen, you can drop a link to that in the chat. I know that it's also shared with everybody who registered today. These resources are written in plain English by John and I, so I can guarantee that they're easy to understand and also have fun examples. Or I'm biased. I think they're fun examples.
Great. So let's change gears and talk about samples, remixes, interpolations, and beats. So John, first off, I find that a lot of people use these terms interchangeably. Can you explain what each of these terms are, and maybe provide some examples so people can understand better?
I think Holland and I are going to trade on and off with the kind of quick definition, and then Holland will give the example. But you're absolutely right that these terms get thrown around a lot. They could be particularly confusing, especially for sampling. People tend to use the word sample to cover a lot of stuff. Sampling, though, we generally think of as taking a part of an existing sound recording and incorporating it into a new work. So when you hear sample, think audio.
I can give a fun example of samples. Well, okay, I can give two, actually. So the first would be Kanye West's Stronger, which samples Harder, Better, Faster, Stronger by Daft Punk. And then another one would be Charlie XCX's Boys, which samples the coin sound from Super Mario Brothers.
I think that's pretty cool.
Yes.
Yes.
So a remix involves like taking an existing sound recording and then adding, changing, or removing sounds to make a new version of the work. So maybe think of it as potentially a subset of sampling.
Or you could think of it how when Billy Ray Cyrus's vocals were added to Old Town Road, among other changes, this created a remix called Old Town Road Remix.
Yeah, I feel like whenever I hear a remix, I mean, like, this is dating myself, but I always think of the Destiny's Child song where Wyclef Jean says, it starts it with, "This is the remix. Radios play the remix." That's how old I am. But yeah, that's what I think. that's what I think about when I think about music. It's like the next version, or you might consider it a derivative work if you're nerdy like me. All right, let's talk about interpolations. An interpolation is different because we're now out of the sound recording world, we're in the musical work world, and so an interpolation involves taking a part of an existing musical work and then incorporating it into a new work. So if a cover recording just re-records a musical work, it's not necessarily an interpolation, but an interpolation is kind of the use of the underlying musical work into a new work. So Holland, you got an example for me?
Yeah, and interpolation is a funny word, and every time I hear it, I'm like trying not to laugh. So, but okay, so I guess an example I would give is Nas's "I Can," which interpolates Für Elise from Beethoven, and I think somebody actually mentioned Für Elise earlier in the comments. So I guess great minds think alike.
Yeah, and I think that's I was going to mention this in a second, but that's a good example because that the Beethoven song is not protected by copyright, so you can do that no problem.
Because it's in the public domain. Because it is for 1924. Is that what we're at right now? Anyway, it's in the public domain. Anyone can use it.
Right, and so like the last concept we were going to kind of mention here are beats, and beats are generally thought of as the backing track to a finished or unfinished song. And it can contain samples and interpolations.
Do you need an example there, John?
Why don't you hit me with one?
Okay. So when young Kyo used the Nine Inch Nails song to make a beat, he then made that available in an online beat store, which I think we might talk about in a little bit. And Lil Nas X purchased the license to use that beat and then added lyrics to create that Old Town Road song that I just mentioned.
Right. So, we have a handout, I think, that we'll mention in a second that uses these examples and kind of walks you through all the different permutations of kind of what to think about when you're talking about, beats, remixes, samples, mashups, things like that. But it's really interesting to use the Old Town Road example because you, of course, have the underlying work, which is the Nine Inch Nails song. You have a producer who, sampled it. And then ultimately there's a remix called the Old Town Road Remix. So it kind of hits a lot of the different points of what we're talking about here. So we think that example is pretty fun.
Yeah, John, if I'm remembering that handout correctly, I think you included examples from like Bob Dylan and Missy Elliott in that one. So the audience is in for a treat.
It's a lot of fun. We have fun at our jobs.
Yeah.
So let's talk about, if someone's wanting to utilize a sample in a work that they're creating, or if they're wanting to remix a song, is it advisable, John Holland, for the person to seek permission to use those pre-existing works?
Yeah, so in most cases, like by and far, most cases, yes, you should try and get permission. I will say though, like we just gave an example of a work not being protected by copyright, the Beethoven song. Nas could use that musical work to make a beat in a song of his own. You wouldn't need a license for that. In other cases, like fair use could cover the use, as a sample, for example. So I think a good example of that is when Living Colour put out the song Cult of Personality. It sampled President Kennedy's 1961 inauguration speech as a government work that would not be protected by copyright. So that band could use that no problem. But in most cases, you'll need to clear the sample. And, how to do that, I will say, this this kind of quote like really applies to a lot of different circumstances in the music world. But I remember Taylor Swift was asked, like, anyone who wants to be a singer, what's some advice you would give them? And her answer was get a good lawyer. And like, frankly, that is really appropriate because, this is part of what publishers and, to a greater extent, sound recording owners do, labels, and they go out and they clear samples. And if you don't have those resources, I would really suggest getting a lawyer to help because you really need to know what you're doing to clear a sampler interpolation.
Agreed. And so this brings up a question that we received yesterday from someone who's attending about, well, I'm wanting to, maybe utilize some lyrics of someone else's song and something else that I'm writing, or, maybe using like a sample, and I hear the term clearing or rights clearance. How do I go about doing that? And so, or, how do I even identify the rights holders in these pre-existing works? With respect to the underlying musical work, a great place to figure out which party controls the copyright in that underlying musical work, go to the PRO website, so ASCAP.com or BMI.com. And there you can actually search their database, by song title, by songwriter, and then that way too, once you actually find the title, you can click on it. And then in most cases, it will actually show you, okay, this is the music publisher that controls this underlying musical work. And it will give you that party's, email address or phone number. So then that way, at least you can identify, who controls that underlying musical work. And then on the sound recording side, usually you can just kind of Google around and figure out what label owns or controls that sound recording. And so the first step is just identifying those parties. And then from there, I highly suggest finding a lawyer to help you with that clearance process.
Yeah, and I'll really plug the one place that we like to look is the Copyright Office, because you can record, not only register your works here, but you could record like transfers. So some sources may have the original copyright owner, other sources might not. Why not look at the Copyright Office? I mean, I would put it in the mix too.
Yes, that too. John, can you provide some information on Beats and Beat stores?
I can. So we have a big long handout on this, and I'm going to give you some of the highlights because it's something that is growing in importance and certainly got the attention of a senator who asked us to create this handout. But beat stores can be great, especially if you're not a composer and you want some help to make some music. But these beat stores typically don't negotiate with their users. They have a menu of options from high to low prices, and generally the higher prices give you more rights. But like any other agreement, you really need to figure out whether it fits your needs. So you'll have to consider things like, are there restrictions in the license that you're getting? Maybe they might list the formats that the beat can be used in. They might be listing how the beat can be used, or what rights are involved, or how many downloads can you sell, or when the agreement expires. I mean, you also want to know, especially based on what we've been talking about recently, does the beat contain samples or interpolations? Because, for example, Young Keo licensed that a beat from a beat store to make Old Town Road, but that beat store, didn't have the underlying license to the Nine Inch Nails song that it was based off of, right? So I'm glad it all worked out in the end, but that could have gone a lot differently. And I think I said Young Keo licensed the beat. Young Keo made the beat and put it on a beat store, and then Lil Nas X licensed the beat to make Old Town Road. So you need to really make sure that if you're buying a beat, that beat maker has all the underlying rights that they need. And sometimes you can tell that if the sample is really clear. Like, for example, if you hear Michael Jackson singing and somebody who is not Michael Jackson is licensing it on a beat store, maybe make sure that you are actually getting all that you think you're getting. Sometimes it's not, and that can be challenging though.
Yeah, so I think, word to the wise, whenever you're visiting beat stores, looking to license beats, make sure you read the actual agreements on the beat store website so you can know what rights you are getting. And a lot of the time, these stores, there are tiers with respect to the beats that you might be licensing. And generally speaking, the more you're paying, probably the more rights you are getting. But, just like with what John said, there might be certain limitations, there might be renewals, limitations might be based on the amount of streams on the streaming services or views on YouTube. So you just need to make sure that you pay really close attention to the terms and conditions of that particular agreement for the beat store.
Right. So free doesn't really mean free when it says free, right? They're going to try to get paid on their own if your song becomes a hit if you use a BeatStar. I think that makes a lot of sense, but the labeling on some of these stores is confusing, and it might think you have all the rights that we were talking about before when as Gwen was just saying, there's a lot of limitations on those rights that are in their licenses, even if it's free.
So, we've gotten quite a few questions on this issue, and I've seen quite a few pop up in the chat as well about, what am I to do if someone utilizes my work without my permission? What should I be doing? Holland, can you give some information on this?
Yeah, definitely, Gwen. And like I mentioned at the beginning of this presentation, unfortunately, John and I can't answer specific questions about copyright infringement, but I can say generally that if your work is used unlawfully, that is without your permission and not under the statutory limitations or exceptions that we've mentioned here today, it is your right to pursue legal action. However, you do need to register your work with the Copyright Office before bringing that infringement lawsuit for your US work. So that's just another good reason to register your work. And I should also mention, some folks in the audience may have heard about the CASE Act or the CCB, or Copyright Claims Board. Historically, copyright lawsuits were decided in federal court, which was and still can be somewhat expensive and really time consuming. So in December of 2020, Congress passed the CASE Act. And the CASE Act directs the Copyright Office to set up the Copyright Claims Board, or CCB for short, to resolve disputes over damages totaling less than $30,000. It's intended to be a cost-effective and streamlined voluntary alternative to federal court, and it'll be available in spring of this year. So I think maybe, Gwen, if you could either drop in a chat now, or if folks wanted to look at their registration information, we have a link to sign up for CCB notifications, so you can find out when the CCB will be available during spring of this year.
Dropping that in the chat.
Awesome. Thank you so much.
Let's move on to some misconceptions in the music world, and some trivia.
All right, so I think I got the first one here. True or false? You could use up to 30 seconds of a song for free without worrying about copyright.
I can answer that one, and folks can also pop what they think into the chat. But I'm going to go ahead and say that is false. You can't use any minimum amount of copyrightable work that's protected by copyright without getting a license, for example. No freebies. No free samples, to use a pun.
Oftentimes I see people say, for some reason, I don't know where 7 seconds came in, but that's usually what I hear. Oh, well, it's 7 seconds, so I can use it. No, you can't.
Right.
Oof.
Which is not to say that longer or shorter uses might not be considered fair use or not. It's just that there's no preset number, like a magic number. It says, okay, under 7 seconds, under 30 seconds. And you can use it. It depends on this. Fair use very, very clearly depends on the circumstances of each use.
John, that was it depends answer.
And you must be going to law school at night, Holland, I swear. All right,
next question. You can register your band name for copyright protection. True or false?
That is a definite no too. We're going to speed through this because I think we want to save some time for comments, but I'll just give you the answer on that one. You cannot register your band name for copyright protection. You may be able to register your band logo for copyright protection, unless it's a common symbol, typography, or short phrases. The band name is generally considered a short phrase, but if a band has a great enough logo, it could be protected. The PTO, or the United States Patent and Trademark Office, is a separate government entity that does register trademarks. You may be able to register your band name there. I don't want to get too much in the weed on trademarks because the PTO is a real expert on the ins and outs of that. And so you can contact them if you have questions.
They have a great help desk too. I think I can take this. Oh, sorry, Gwen.
Oh, I'll just go ahead and ask. True or false, Holland, you can mail yourself a copy of your work as a poor man's copyright.
Gwen, I was going to try to stump you with this one, but I know that the answer is also false. You get copyright protection when you create your work, but there is no stand-in for copyright registration. If you want to register your work to provide an official record of your work or to pursue a copyright infringement, you have to register. You have to register with us at copyright.gov.
Great. So we're going to move on to some questions. One of the first questions I got earlier this week: if I register an unpublished group of works, but later publish those works, do I need to re-register that group of works again as published? Can I file a copyright infringement claim by having registered the works as unpublished?
So if you had a copyright registration is a snapshot in time, right? It says who the authors are, who the copyright owner is at that time, and what circumstances, including whether it was published or not, were in effect. So as long as you are honest in your copyright registration, you should just put forth the information that you know. And if it's unpublished at that time, that's fine. You'll still have a copyright registration after you publish it. You could supplement your registration to reflect the fact that it was later published, but you don't need to. So it's optional to do that. You will still have a copyright registration that is valid.
Great. Another question. If ownership of a work changes after a registration certificate was issued, is there something that new owner needs to or should file with the Copyright Office to reflect the change in ownership of the work?
I think we talked about this really briefly before, but you can submit a copyright recordation. The Copyright Office has registration, and that division deals with copyrightability. Recordation deals with the other issues. So transfers is kind of the biggest one. And if you want to reflect that someone else registered a work and you now own it, then you all can go to the Copyright Office and record that transfer, and it will list you as the new copyright owner in our records. You don't have to do it, but it's helpful.
So I see someone asked, can you go over the standard application again? What way to register musical work and sound recording at the same time? Can you give an example?
So I can give an example. Let's say I write a song and I record it on my computer. I am now a copyright owner of a musical work and the sound recording. If those are put into the same MP3, and for example, like when you register works, there's all these different rules about what they prefer for, a work, right? And it will include formatting and things like that. But for a musical work, it is certainly allowed to register your musical work as a phonorecord as the deposit, and that single deposit, just make sure you have one deposit. So like one MP3, one CD, whatever it is, and you submit it to the Copyright Office, and I'm the author of both, then I can indicate on the application, I am a sound recording owner and I have a musical work owner of this song. Now, if you're asking me the question about what buttons to push on it, I am less familiar with Echo, which is our registration platform. We're building new platforms that are hopefully a little bit clearer, and I will be more familiar with those in time. But I spend too much time in the General Counsel's office and less time in the registration program's office. But as Holland was suggesting before, you call our public information office. They're really helpful in being able to tell you which buttons to press to trigger that.
Great. Another question, thoughts on first use mechanical rights among joint authors?
So, right, one of the things that I think Holland alluded to is that traditionally the statutory mechanical license was only triggered once the first use rights were exercised. And I would understand that because each joint author is an owner of the whole of the copyrighted work, if they are authorizing the first use of the work, that would have historically covered any use of the work. You don't have to have all the joint authors agree on the first use of the work. And so, as far as I understand, I've never heard anything to the contrary. And I will say that there are some exceptions, and that changed a little bit. The first use provision for digital uses of the mechanical license, but that's a little bit too in the weeds for this presentation.
So I think that this person had a question about the Graham application, and maybe questions about when you have maybe one common party that is a common author or a common claimant. Could you kind of explain that a little bit more, so then that way this person can maybe understand that application a bit better?
So this is actually an issue that I'm very well aware of. Claimant means two things in the copyright regulations. So an author of the work is a claimant. If you have joint authors, each joint author of the work is a claimant. The other way you could be a claimant is if you're an owner of exclusive rights in the work. And so, for example, if the three of us write a song and then we license it, or we assign our rights to a publisher. That publisher has all of our rights. They have exclusive rights to the song. They can be a claimant. And this is the tricky part, if a joint owner assigns their rights in a way that someone stands in the shoes of them, right? Like eliminate me, put in my buddy who now has all of my rights, that person can be a claimant. And that is a little bit tricky because the claimant rule doesn't change for the Graham. And there was some language, I think, online that was a little bit confusing for that. But the claimant rule is always the claimant rule. You have to be an author or someone who has the exclusive rights in a work to be able to qualify as a claimant. And so the one kind of other piece for Graham that I'm trying to remember is that to qualify under Graham, you have to have a unifying author, which is separate from the claimant. So, if Drake had other writers or other musicians on his album and he wants to register the musical work, as long as Drake's on every track, then Drake is the unifying author. But that is a different concept than claimant. Claimant, again, has to be an author or the owner of the exclusive rights in the work.
Here's another question. Let's say that a poet signs over his composition and phono recording to a producer. Does this mean that he can't use his poem for other purposes?
So like this is one of those ones that is getting closer to like legal advice, but I think, Gwen, you could probably give your best answer to this one.
Yeah, I mean, I think it comes down to, what rights are being signed over. Are we talking about like a full out assignment of copyright in that particular composition, in that poem? So, I think that if this is a specific scenario you want to talk through, I'm going to drop an email address in the chat here where we can find a time to, discuss this in greater depth. Because that's one of those things, like, I understand that people have lots of questions when, they're watching these webinars, but a lot of the time it's hard to answer questions without getting the full set of facts around the circumstance. And the last thing that we want to do, and especially the last thing that anyone at the Copyright Office would want to do, would be to, provide incorrect information because we don't have all the facts.
And I think people would be surprised at like which facts actually trigger kind of a different answer. It's really, the legal world is challenging in copyright for sure. And, the most minute detail can change our answers. And in some ways that might be surprising, but, the answer a lot of lawyers will give you is it depends. And that's like no different right now.
I've heard that one before, John.
So I think looking through here, I think that these questions have pretty much been answered. And like I said, if there are questions that maybe you think about later and you're like, oh man, I wish I could have gotten this answered, feel free to shoot an email to legal@talarts.com. It's in the chat here. And finally, what I wanted to do was provide a little bit of background on TALA, Texas Accountants and Lawyers for the Arts. So TALA provides pro bono legal and accounting services to individual artists and arts-related nonprofit organizations from all creative disciplines, including like music, visual arts, writing, acting, dancing, performing arts. And we also at TALA have a partnership with the U.S. Patent and Trademark Office. And so it might be the case that TALA can provide inventors with some assistance with respect to filing a patent. I know that this typeface is kind of small, but this is kind of like an example of some of the different sorts of areas that TALA can provide assistance with respect to. So, you need help registering copyrights or trademarks, or let's say you get a recording agreement and you're like, what does this mean? Or questions about, licensing of art or work for hire agreements, or if you need some, general tax advice, or annual nonprofit budget planning advice. One thing that TALA can't help with, we don't deal with family law, criminal law, litigation, bankruptcy, audits. So you can see all of that here on this slide. And on this slide, you can see what the member qualifications are. And you can also find this on the TALA website, which is talarts.org, talarts.org. And finally, here is the member fee information. And, if you have questions about TALA, or, you have some questions about whether or not you qualify, or whether or not some issues that you might have might be able to be assisted with from some pro bono lawyer volunteers with TALA, feel free to also email TALA at info@talarts.org. And down at the bottom, you'll see a little banner that gives you some of that information as well. And finally, I do want to mention that TALA offers an arts legal line multiple times a year. And so the dates are here. And so, if you're anywhere in Texas and you have some questions, whether, they're copyright questions or maybe trademark questions or questions about, you're a band and wanting to form an LLC, for example, or questions about split, just about anything arts and entertainment related, you can call in to the numbers located here on your screen from anywhere in Texas, and you will have a lawyer help you out with your particular questions. So on that note, I think we have reached time here, but I really just want to thank the Copyright Office, John and Holland. You both have been absolutely amazing, and thank you so much for taking the time to do this and help Texans recognize their rights and understand copyright law better.
Thanks, Gwen. This was fun.
Yeah, thank you too. And it's the music world is so complicated. It's really kind of just touching the surface of a lot of topics here, but that's okay, because if you have a little bit of understanding, it'll give you the direction to get more. And I think two good ways to do that are the resources that Holland and the office have provided and put in the chat and have distributed. Certainly a lot of the topics we go in more in depth there. And then the other one, of course, is to talking to attorneys and organizations who are going to help you along your way, like Tala. So I will say thank you again. We really appreciated the time and hope to do it again someday.
Absolutely.